Hi, friends. Um, I'm here today to talk a little bit about the role of a lawyer, and I want to expand a little bit on the way that we traditionally think of a lawyer and their role. Um, there's been times when I've given talks or otherwise talked to heads of businesses about being a lawyer, and they they typically say, well, we don't have any legal issues to deal with. And you get the sense that what they're really saying is nobody's suing us. We don't have a need to go to court right now. We don't need to sue anyone, nor are we being sued. As if the only thing lawyers do is sue people. And I like to think of myself less as a professional litigator, although I can litigate with the best. But I see myself more as a professional problem solver. And I would ask you, if you're coming up with the idea that we haven't had a legal issue for a while, have you got an uncollected bill? Have you had to terminate an employee? Do you have any legal documents that you've signed or negotiated or offered to a client or customer without legal review? Is anyone producing cut rate products and passing them off as yours on the internet? Have you ever been accused of unethical business practices, either by an employee or by a vendor or a customer? Have you been accused of sexual harassment, or has any officer in your company been so accused? Are any of your employees dating each other, potentially creating those kind of implications? Do you have sensitive customer, vendor, or pricing information where it could be damaging if that information were known to others in your industry? Do you ever have questions about employee safety requirements, environmental issues, zoning or planning, or other municipal issues? These kinds of issues often significantly burden your CEO or other senior management. And typically they're not things that executives are particularly good at dealing with. Oftentimes they feel like they're taking their best shot in the dark and hoping they don't get in trouble. And so I'm suggesting that when you have problems of this kind, if you have regulatory problems with a government agency, if you need to terminate an employee and you need to know what records to keep and what records to create, anything where you have issues that could potentially come back to bite you, these are issues that keep CEOs and other senior management awake at night, and which your company's attorney is much better equipped to deal with than most senior management. So I'm trying to get you to let go of the idea of involving a lawyer only when all other efforts have been tried and you're definitely now heading to court. In fact, for me, as a lawyer, my very first objective is to keep the problem from happening in the first place, to solve it before it ever occurs. The second is when the problem is discovered, if something happened and we weren't able to solve it prior to it happening, to address it and get it solved before it gets big. And of course, the final last resort is, all right, if it's already big, then we're going to pull out the litigation card if we have to. But by the time you get a case to litigation, everybody's going to lose to some degree. And so there's an important role for an attorney in dealing with problems before they get to that point. Let me give you an example of a situation that might have been made better by having proper legal documents. I was close to a situation a few years ago where there was a man I know of who was incapacitated because he was in late stages of a terminal illness. And he had a pretty large number of children and a wife. And several of the children were okay with terminating life support when pretty much all hope of him regaining consciousness was gone. And another number of the kids were not okay with that. And the mother had to make the decision. And it caused significant hard feelings and problems in the family when the decision was made to terminate life support. Even to the point that some of the kids, may have disowned their mother and said awful things and, created problems that in some cases can last for a generation. Now, I'm going to suggest that let's suppose this person had had a medical power of attorney and an advanced healthcare directive that had spelled out the circumstances under which he would have wanted health care to be terminated and life support measures to be terminated. I'm going to suggest that the spouse at that point could have taken that directive to the kids that were worrying about it and handed that to them and said, hey, I'm just carrying out Dad's wishes. What effect do you think that would have had on that family? Now look, it's a secondary consideration whether that document would have held up in court. As an attorney, I will draft it to make sure it does hold up in court. Whatever the document is, I'll do my best to make sure it's legally valid. But in this case, that's a secondary consideration because you hope that this family doesn't go to court over that, one way or the other. And I don't believe there was any talk of that, even without the paper. But having that in hand and being able to hand that to a child and say, look, this is what your dad wants. This is his wishes. That would have taken a lot of burden off of his poor wife of having to not only make that decision, but defend it to her children. And so that's just one example of, hundreds I could pick from of preventive lawyering and where problem solving, even in advance before the problem even comes up, anticipating and solving a problem isn't purely a legal service. I mean, it is. But there's a lot of things that I will do as an attorney that don't, strictly speaking, require me to go into court and prove something. Another example might be if I've got a client who's got people infringing their trademarks by trying to sell under their name on Amazon and it isn't their product. It's not them doing the selling. There's things that I'll do short of going to court before just filing a lawsuit. One of those things might be write them a letter and say, hey, I've noticed you're posting ads on Amazon that are infringing our trademarks. They're trying to pass your goods off as ours. We know yours are not of the same quality and they're not made in the same way and whatever. We need you to stop. Cease and desist letter. Okay, that would be the first thing. And a lot of times that will put a stop to the illegal conduct, the trademark infringing conduct. I've done it, seen it work. What if that trademark infringer is in China, which I've seen too? And, you know, you could try sending them a certified letter from the United States and it might get to them and they might read it, but they're in China. They're saying, fine, jump in the lake, come and get me. Well, what can I do about that? Short of filing a lawsuit and then trying to enforce it in China, enforce the judgment in China. I can go to the company that runs the website or that hosts the website, or in the case of Amazon, go to them, and I can ask that those ads be taken down, and I've done that numerous times. I've had numerous ads removed from Amazon, and then on other websites, there was a website that a competitor had developed a whole website as a counterfeit to my clients, and they were selling cut-rate products under my client's name. I went to the company that hosted the website, which was a Chinese company, and I asked them to take the website down, and they did it. I sent them a letter on my law firm letterhead and explained the law as I understood it that was applicable, and they took the site down. Okay, I've done things like that a lot, and you know, I didn't have to go in and fight something out in court in order to do that. So that's another example of things that are in my wheelhouse that I can do that touch and concern the law, but that strictly speaking, they're outside the box of the legal remedy. And if I can address a problem soon enough before it gets really big, sometimes the lesser measures are going to work before I have to, you know, go to the headache for everyone of filing a lawsuit. I've touched before on the idea that an attorney is both a warrior and a healer. The warrior is called for most when there's a power difference between two parties that are in dispute. It also may be called for when you've got someone who's a serial corner cutter or a serial infringer of trademarks and things like that. Someone like that, you may have to take a more aggressive approach. As I've mentioned at other times, I'm not, in terms of style, a pit bull litigator. A lot of people think they want a pit bull. And pit bulls are expensive. They shoot first, ask questions later. They file a lot of unnecessary paperwork. They tend to push things to litigation and be very contentious about it, and they're a pain to deal with. And you deal with them a lot because they're running the fees up. And I'm suggesting that there is a time to be a warrior, but it's not every time all the time. And the ones who do that are called pit bulls, and justifiably so. The judges and the other attorneys know who they are. And anyway, you want a warrior for certain situations, as I've described. You also want a healer. Someone who can get you out of conflict and allow you to move forward. Someone who can give you closure to a difficult situation. And as I've mentioned, not all of the tools in a lawyer's toolbox are related to court. If you need to collect money, there's going to be several steps I'm going to go through before I go to court over it. Number one, because that's easier and cheaper for you if those methods work. And you know, I may write a letter to a client or to another party, for example, and say, you need to pay this bill, $10,000 or whatever. It's now 90 days overdue, and I see a former client of mine on here. Hi, Manuel. Anyway, you may write, and you may say, well, why do I need you? I could write a letter and save myself the $300 or $500 or whatever it costs. I'm going to tell you a couple of things. Number one, a letter from a lawyer is always more persuasive. I hate to tell you that. It's going to be more well written. When it's written by me, it's going to be fortified with legal authority, appropriate to the situation, because if the letter doesn't solve it and you have to go to court, you're going to have to do the legal research anyway, and doing it before you write a letter is going to make the letter feel more authoritative and give you a better chance to settle your claims before they ever get to court. Secondly, the fact that it's on my letterhead is going to make it feel more serious. And think about it yourself. Let's suppose you're at a time when you're particularly short on money in your business or whatever. And you have all of these different bills to pay and you don't have the money to pay them all. But with one of those bills, there's a lawyer writing you letters saying, hey, if this isn't paid by a certain date, we're going to pursue legal remedies. Which bill are you likely to pay first? Okay, you all know it. When you're getting letters from an attorney, you're going to pay that bill first. If there are, if there are other bills, you're going to put those off because, let's face it, who wants to be sued? Who wants to deal with a problem that way? You're not just the squeaky wheel then, you're the one with a hammer. And I'm not suggesting you wield that hammer, indiscriminately. Getting a polite but strongly worded letter from me is going to have a lot more effect than getting it from you, even if you're the CEO or a high officer in the company. Just a fact of life. So, when I think about the tools in our toolbox, you've got legal demand letters. You've got negotiations, and I am open always as an attorney to trying to come up with a creative solution. Let's suppose that client just doesn't have the money to pay you right now, or that customer, whatever. All right? I can't get blood from a stone. I could take it to court and get a judgment in your favor. Maybe it's a very good case, and maybe the other person's not even going to fight back because they don't have the money to hire a lawyer themselves or whatever. That judgment isn't worth the paper it's printed on if the other party doesn't have the money, right? So what am I going to do? Well, what if I work out a payment plan with that person? What if I get their credit card information voluntarily and they sign an authorization and we get them to pay $500 a month until the bill is paid off, or $1,000, or whatever it is. And we have an auto pay set up so that we don't have to keep going around hassling them. What is that worth to you as a business owner to have a solution like that worked out? It's not perfect, but hey, let's just go to court and try to get money from somebody that doesn't have any, and then try to collect it when they're mad and hiding it, or they've spent it all on lawyers. You see what I'm saying? The kind of lawyer you want for your business is a professional problem solver. Someone who's got a lot of tools in their toolbox, not just a hired gun with one 6-shooter and 6 bullets. You want somebody who can think creatively, think outside the box, find a way through your problem, get it over with sooner rather than later, and who's got the 6-shooter in his holster if he needs it. I've litigated a lot of cases. I'm not afraid to do it. It's something I know how to do better than most. But It isn't my first course of action. I don't shoot first and ask questions later. The big objection that I hear to hiring lawyers and getting them involved earlier rather than later is, well, lawyers are expensive, and it may be true that a letter coming from you is more powerful than a letter coming from me, but I want to try the letter coming from me first, and then later, I'll bring in the lawyer as a last resort. There's a couple of problems with that. Number one, I've seen a lot of executives go too far and create an even more difficult situation with the customer or vendor before bringing the lawyer in, who's more objective and more outside the situation. And then my work is a lot harder, and I've seen this so often that I think it's always a danger. Another is early involvement overall is going to decrease the cost for all of the reasons that I've mentioned. Third, it gets it off your desk, and your time is valuable. You need to be focused on doing the things that make your business money, not solving problems, not dealing with issues. Now, you're going to do some of that, obviously. You got 2 employees that aren't getting along. You're not bringing your lawyer in to fix that most of the time. But when you're dealing with problems with customers and vendors, or if you've got an employee that is disgruntled and maybe needs to be terminated, bring your lawyer into that. Make sure you do it right. All right, so address things soon. As I said, my first preference is to help you solve something before it becomes an issue. To have you ask me legal questions and set things up document-wise and otherwise. Set up your processes and procedures to avoid trouble. Inevitably, some problems are going to arise anyway. And then it's to address it early before it gets big. And only as a last resort do we dive into litigation and pull out that gun. So, anyway, I hope this was informative and thought-provoking, and that you will consider a business lawyer as more than a hired gun, but primarily as a professional problem solver that can help you take care of the things that are important to you in your business. Anyway, we'll talk to you soon, and I appreciate the opportunity to speak to you and hope that this has been helpful. Thank you.